I mean, shouldn't we all worry about keeping the judge happy? Aren't they the most important person in the room? And so a lot of people think that, and if that's where your head went, you're not alone, but you're also not correct. And so the judge is actually not the most important person in our courtroom scenario. And so if it's not the judge, then who is it? Well, the most important person that we need to be concerned about is that minor child. And it's unfortunate, but kids really don't often occupy that important place that they deserve. And it's not because I think that the court participants want it to be that way, but I think it's just that they get lost in the shuffle. During all of this legal wrangling and back and forth that can go on, we lose sight sometimes of how important those kiddos really are. And so we're going to start by talking about our most important person. And so this episode is the one it's all about. When we're looking at how a court decides matters of child custody, the very first utmost objective needs to be the best interest of the child. Okay, well, great. That's easy enough, right? We just figure out what's in their best interest and we can all go home and be happy, right? That's easy. But the problem is everybody who's involved in this process usually has a different idea about what the best interest actually is. And so when we are trying to figure out what this process looks like for a kiddo in the court system, we see some common questions that come up. One question that we get a lot is, does this kiddo need to be present for these court hearings? And so the reality is we don't want that. If we can avoid it, we don't want to put a kid in the middle of a court proceeding. And it's not because we're trying to hide something or keep something from kids, but we need to remember a couple of really important things here. Number one, they're just kids. They're innocent, or at least they should be. And we need to do what we can to preserve that innocence for just as long as possible. And so I know that a lot of times our kids have really seen and done some things in their family situations. But the truth is, we don't really want them having to hear all of the mudslinging and all the bad things that everybody has to say about everybody else. We want our kids to stay out of that and have as far removed from that process as possible. Aside from that fact, though, we also have to remember that kids, they're still developing their emotional health. They're still developing those coping skills. And this process of going to court and being in the midst of all of that is really emotionally difficult for kids. They feel anxiety just at the very thought of coming to court many times. I think sometimes a lot of kids are afraid that they might be put on the spot and told they've got to make some kind of choice about something, or they sometimes can even be afraid that they might be blamed for this situation. You know, if it wasn't for me, we wouldn't have to be going through this. And so we really want to do a lot to protect those kids and keep them out of that situation. That's not to say it never happens, though. There are times where it is absolutely necessary for a kiddo to come to court. But when that happens, we protect them as much as possible. We keep kids in a separate location so that they're not actually inside the courtroom hearing all the mudslinging. They're there if their presence is needed, but they don't have to actually be observing the actual goings on. Another question we get is about whether or not this child should testify. And so this is the same principle. We want to avoid it if possible for all of those same reasons we've already talked about. But again, sometimes this is a necessary step. And so when a court's looking at whether or not it's necessary for a child to testify, they're looking at things like, how old is this kid? What kind of emotional maturity level do they have? Are they really going to be able to testify and do that without doing harm to them? Again, if it is necessary that a child testify, we make really strong efforts to protect that child. And one way that occurs is the court conducts usually what's called an in-camera review with that child. And so what the judge does is he clears everyone out of that courtroom except the very necessary people. And that's not going to include parents, other relatives, or petitioners in a case. They're not going to be present in the room while that child's testifying, but the people who are representing them, the attorneys that represent them, they will be. But we don't want to put a kid in a situation where They're having to stare at mom and dad and say, well, I don't want to live with dad because whatever, whatever. We want to make that testifying process as safe and as secure as we can for kiddos. Now, I can hear this question coming. I know so many of you are thinking it. What if my kid has really strong feelings about where they want to live? I mean, isn't there a time that they get to decide? And I've heard it all. I've heard people say, well, I heard it was 10 years old, or I heard it was 12. Well, the good news is there is an answer to this question, but the bad news is that you're probably not gonna like it. So the reality is, here in Missouri, a child essentially has to be a legal adult. They have to be 18 years old before they get to say, this is where I'm gonna live. So, does that mean that a child's thoughts and opinions don't matter? Do they feel like Joey and that their opinion is moo? You know, of course not. That's absolutely not what we're dealing with here. Missouri law says that a child's preferences must be presented to the court, but ultimately the court has to decide what is in that child's best interest, even if it doesn't necessarily align with what that child wishes. And so again, when a child's testifying or giving their preference about where their living arrangements should be, courts are thinking about things like this child's age, their emotional maturity. They're thinking about the reasons this child provides. So a lot of times you get a wide variety of answers when you ask a kid about this. I had some kids that would say, hey, well, I want to be at my dad's house because at dad's house, I can stay up as late as I want and I can eat Cheetos for breakfast. Well, okay, that's maybe not a very mature reason for the preference that you're given. But sometimes it is. Sometimes a kiddo will look at me and say, I think I need to live with my aunt because when I was living with my mom, I couldn't always get to school on time. And my mom never helped me with my homework. Well, that's a whole different ball of wax, right? And so those reasons can definitely matter and they can really carry some significant weight with a court. And so the court does have a duty to consider the wishes of a child. Missouri guardianship laws are the closest things that give us a deadline or an age limit where a kid can nominate their own legal guardian. So in other words, the Missouri statute says that if mom and dad are unfit, unwilling, or unable to parent, a child that's over 14 can say to the court, this is who should be my guardian. But even here, the court has to determine whether or not that's truly in a child's best interest. And I'll give you a good example. Let's say we have a 14-year-old kid who has lived with mom during their lifetime. But also during that time, they've spent a lot of time in and out of the home of maybe mom's best friend. Now let's suppose that mom passes away unexpectedly, and there's no one that can step in and parent this kiddo. So mom's friend comes to the court and files for guardianship, and the judge says, hey judge, this is who I want to be my guardian. I've lived with her in the past, I know her, I'm comfortable there. This is who I want to have as my legal guardian. But what if? What if mom's best friend has a drug problem or a history of drug use? What if mom's best friend has a history of child abuse of some sort? So that may not be actually in a child's best interest just because the child nominated that person. The court still has to make the determination about whether it's in their best interest for that placement.
Jennifer, we have a question in the chat that I thought I'd just throw out to you now from one of the participants. Says, aren't kids considered to be adult at 17 in Missouri?
No. And this is a really difficult thing because in the area of child custody, the year between age 17 and age 18, I call no man's land. Let's say you have a 17-year-old who is your biological child, but they become beyond your parental control. Sometimes if you go to the juvenile office and you say, I need help, I can't control this kid, they'll look at you and say, your kid's 17, we're not going to do anything. But yet, At 17, that kid can't go out from your home and sign an agreement to rent an apartment. They can't go out and purchase a car. They can't go out and consent to their own medical treatment. So it's really very much a no man's land, and there's not a lot of guidance, a lot of direction for that year between 17 and 18. So technically the answer is no, they are not adults, but there's not always a good set of resources available for those kids. Okay, so we're gonna kind of backtrack a little bit because we're trying really hard to keep our focus on these kids. And so what I want to do is I want to look at some other things that we should be watching out for. During these child custody cases, it doesn't matter how much everybody tries to protect this child. These kids are stinking perceptive, and they pick up on all of those undercurrents of what's going on. And it can really cause some adverse effects for kids, and those things can come up and show themselves in ways that we might not always expect. One thing that we really find commonly is we start seeing a lot of really anxious behavior out of kids. You might have a kiddo who starts having digestive issues, constipation, diarrhea. You might find them complaining of headaches or stomach aches. You might start seeing compulsive behaviors, counting things, double checking door locks, picking at scabs. I mean, there's a whole host of things. And all of these, if you've ruled out an illness that might be causing it or whatever the case may be, the chances are good that this is anxiety that's showing up for this kiddo. And so these are just examples of some of those anxious behaviors. You may notice others, but you need to keep an eye out for those. You may also see kids start to regress in their behaviors and in their habits. A kiddo who's been potty trained for years might suddenly start having accidents or start wetting the bed. It's not uncommon for us to see kiddos who go back to talking in speech patterns that are younger than their years. And so if you start seeing those symptoms of regression, that can often be a symptom of anxiety for a kiddo too. Behavioral problems can really start to manifest in the midst of these custody litigations. You've had a kid who's pretty well behaved, who suddenly feels like their life is out of control. And it then becomes extremely difficult sometimes for them to be able to regulate their own behavior. And so those modifications to their behavior, normally they're not severe, but they can be. And so if you start seeing changes in the behavior, it's something you want to be aware of. We also need to be mindful of things that turn into self-harming behavior. If you start seeing a lot of unexplained injuries, scars, this is the time when things like cutting or other self-mutilation can really come to the surface. Another kind of hidden danger is eating disorders can actually start to develop during this time as well. I recall I had a case one time where a kiddo came and said, look, I started to develop bulimia because I felt like my parents were divorcing because I was overweight. And I knew in my head that wasn't what it was, but I just couldn't convince myself of that. And so this eating disorder showed up. And so we need to be mindful of all of those sorts of things as well. We also see a lot of people-pleasing behavior. There is so much conflict in these kids' lives that sometimes they just want to avoid more. And so they'll twist themselves into pretzels just to keep the people around them happy. And so you might see kids that start doing things that are out of character, cleaning their rooms without being asked, doing chores for their siblings. They just want to keep the people around them happy so that they don't feel that chaos or that conflict in their life. Unfortunately, we also have to address this possibility too, though. There are times that kiddos are way, way smarter than we give them credit for, and they learn quickly how to play one side against the other. And so you may see a kiddo starting to play one side against the other to get something out of it. And sometimes it's really hard to distinguish between this and people pleasing. If, for example, a kiddo's visiting with their biological parent, they may come home and tell you that they had a terrible time and they wish they never had to go back, but they might be telling the biological parent that, hey, if it was up to me, I'd be living with you all the time. I don't like being at Auntie's house. So it's hard to know if kids are really trying to just make those around them happy or if they're doing that to try to gain some advantages. But the takeaway for all of these is that if you see behaviors in your children that are in your home that concerns you, get help for them. It is so much better to be safe than sorry. It may just mean that they need to see a therapist for a little while so that they have someone neutral to talk to, or it may be something much more serious. But err on the side of caution and make sure that you are paying attention to those things and getting help if needed. All right, so now we have talked about our most important person. We're going to start talking about another necessary party, which is our petitioner. And we're going to call this episode the one with something to prove. Now, petitioners can be a biological or adoptive parent, they can be a family member, or they can be an unrelated party. For example, if a biological or an adoptive parent, they're usually a petitioner if it's parent versus parent. So in other words, maybe a divorce situation. But if you're a family member, like a grandparent, or somebody who's unrelated to the child, you're probably a petitioner in a third-party custody case or a guardianship or maybe an adoption. And we talked about those pretty in-depth last week. We talked about last week your burden of proof and what kinds of things you have to prove in order to prevail. And so if you weren't able to be with us last week, the slides are available and we can certainly get those to you so that you can have that information. We'll go through them just very briefly here again in a moment. We're not going to spend a lot of time there, but do remember that if you are the petitioner, in other words, you're the one starting this case, you're probably the one who has the things to prove. Attorneys are not necessary. So a petitioner can bring a case without having an attorney to represent them. But I would tell you that you are probably really disadvantaged if you don't. And that's because you're held to the same exact standards that an attorney would be. You are charged with the same knowledge of the rules of civil procedure and the rules of evidence. You're treated to have the same knowledge of courtroom protocol. And the reality is that lawyers spend 3 years of law school and years of practice trying to perfect this. Now, granted, I think a lot of times we still sound like bloomin' idiots in the courtroom, but we try, and we've had a lot more experience than the average Joe. And so being held to the same standard, that makes it a really difficult thing in order for you to try to prevail without the assistance of an attorney. Now, if you are the petitioner, you are not entitled to have a lawyer appointed for you by the court. So you may say, I'd like to have an attorney, but I simply can't afford one. The court is not required to furnish an attorney for you, but there may be some resources that can help you. You may qualify for legal aid, and that is like an income-based program that offers free or reduced cost legal services based on your income. And so that may be one way. If you have a child who is involved in the juvenile court process, there may be some subsidies that you would qualify for to help achieve permanency goals like guardianship or adoption. But typically speaking, you are not going to be appointed an attorney by the court. We're going to briefly recap those burdens of proof that we talked about last week. We're not going to spend much time on the first one because we're not probably dealing with many folks who are fighting parent versus parent. We're probably not too many of us in this divorce situation or motion to modify. So we're going to kind of breeze past that one. You may find yourself in one of these final categories, though. You may be attempting to get third-party custody. And if that's what you're trying to go for, you have to prove, according to the statute, that the parents are unfit, unsuitable, and unable to parent, or that the welfare of the child requires it. If you're wanting to look for guardianship, and this is through the probate court, you have to be able to prove that the parents are unfit, unwilling, or unable to parent their child. And finally, we looked at the grounds for adoption last week. And I won't take the time to read all 7 of those grounds. Like I said, the slides from last week are available if you want more information about that. But the burden of proof is with you as a petitioner most often. And so what if you're not the petitioner? What if you are the other side of that coin, what we call the respondent? Well, this episode is called The One Where a Response Was Requested. And so respondents are usually biological or adoptive parents. So for example, if it's a parent versus parent case, One parent would be the petitioner, the other parent responds. If it's a third-party case or a guardianship or an adoption, it's someone else who's petitioning the court, and then the parents have a chance to respond. So their response is requested. Like petitioners, respondents can be pro se. In other words, they don't have to have an attorney, but also like petitioners, they probably shouldn't do that. And it's for the exact same reasons. They're charged with having the same knowledge as an attorney would have. For the most part, respondents are also not entitled to appointment of a lawyer by the court, but there are some exceptions. One is where the parents' rights are potentially going to be terminated. Because remember last week we talked about that constitutional right of a parent to raise their children. So it's really a tough thing sometimes to sever that parent-child relationship on a permanent basis. And so the law suggests that best practice for courts is probably to go ahead and appoint legal counsel for a parent who can't afford an attorney when termination of that parent's rights is sought. And that's because I've heard judges describe this termination of parental rights action as basically the equivalent of the death penalty, because it is a permanent remedy. And so courts don't take that lightly, and they do try to make sure to afford as many constitutional protections as possible. But that being said, typically speaking, respondents are not necessarily appointed court-appointed attorneys either. And I will also say that the parent does usually have to be actively participating in the case in order to get the benefit of a court-appointed attorney. And I say that and make note of it because respondents aren't required to participate. In other words, they can't be taken to jail, they can't be fined, they can't have any sort of negative consequence for not appearing in court, except if they've been served and they don't file a response and they don't come and participate, they're considered to be in what we call default. And in that case, the petitioner usually gets the remedy or the relief that they've asked for. So they're not required to participate, but if they don't, petitioner usually gets what they want. So that is our respondent. Now, if you are the petitioner, we strongly recommend that you do have legal counsel. So we're going to talk about who our petitioner's attorney is and what they do. And this is the one who is in it to win it. And so when you have an attorney that represents you in these matters, they are usually extremely goal-oriented. And so hopefully these lawyers will sit you down and they'll explain to you, here's how I think we can help prevail in your case. But they also need to be really candid with you about, hey, here might be some potential problems with your case. And I would always tell folks, you should be extremely leery of any attorney who says, oh, this is a slam dunk. Because the reality is that no such thing exists. There is no case that is a slam dunk. Instead, that attorney should go over the actual facts of what's going on with your case, and then they should give you their best opinion of the likelihood of success. Attorneys should also give you advice about what types of evidence you're going to need to present. Not all evidence is created equal. Some things may do more to prove the required things than other types of evidence. Now, if you feel strongly about a particular piece of evidence being offered, you need to discuss that with your attorney. They may say, hey, look, that doesn't prove what you think it proves, and here's why. Or they may say, hey, we can offer that, but I think it would actually do more harm than good, and here's why. Or they may say, hey, yeah, that's great, we can use it, let's do that. But the point is, they are there to guide you through that process and help you understand what evidence you will actually need to present. Now, this point can actually be a little bit tricky for attorneys. As attorneys, they should not be making backroom deals that undermine your legal position. But any good attorney should be giving you an idea of what some reasonable compromises might be in your case. And they may actually recommend to you, hey, let's make a settlement offer to try to resolve this. But if you tell your attorney that you don't want to settle your case, they shouldn't be going behind your back and trying to make settlement arrangements. Now, that being said, you should be able to trust your attorney's experience, right? I mean, that's why you hire them. So if your attorney comes to you and does recommend some sort of settlement or compromise, you really probably want to consider it. They may have access to information that you don't know, and they should be able to present that settlement or that compromise to you and tell you why they think it would be in your best interest. But it's really super important that if you don't fully understand the potential settlement offer, you need to ask as many questions as necessary in order to help you understand it. Now, if your case can't be settled, and that certainly happens, if it can't be settled, it has to be tried. In other words, the judge has to ultimately make the decision. And if that's the case, your attorney needs to explain that trial process in a way that makes sense to you. So again, the major takeaway here is if you don't understand something, you should ask. Sometimes I get clients who say, hey, I had an attorney and I talked to them and I told them I didn't understand and they got really mad at me and they really didn't want to take the time to explain. Well, if that's the resistance that you're getting when you try to talk to your attorney, it unfortunately might be time to evaluate whether that's really the best attorney-client fit. Sometimes it happens where personalities just don't mesh. If you're not getting your questions answered to your satisfaction, you might need to look for a different attorney. Now, you do need to have realistic expectations of what an attorney can do for you. Keep in mind that they are an officer of the court. They have obligations to be respectful and to be appropriate both in and out of the courtroom. They can advocate for their client, but they can't really be a jerk about it, and if they are, they may be subject to discipline from the Missouri Bar. They also owe a duty of candor to the court. In other words, they have to be truthful with the court, and they can't let their clients mislead the court any more than they can. And so I've had clients say over the years, well, if I need to say such and such in order to win, well, I guess I kind of do remember it happened in that way. And at that point, I have to have a serious conversation with my client about how, hey, look, I know you were just joking, but if I thought for a minute you weren't and that you were going to get on that witness stand and lie, I can't let you testify. And now I'm in a conflict of interest position and I'm going to have to withdraw from your case because I can lose my bar license for that. So just don't expect them to do that. Know what the realistic expectations are. Attorneys are also bound by the rules of professional conduct, and that governs how we interact with the court, with other lawyers, with our clients, with other parties and witnesses. And so no lawyer is going to risk their livelihood just to win your case. So know what those expectations are. Now, the respondent's attorney is a little bit different. They're similar in many ways, but different in some very significant ways. A respondent's attorney can't guarantee an outcome either. They have the same duty to explain the likelihood of success based on the facts of the case. They also should advise you about what evidence might be beneficial for your case. So far you can see that these are really pretty identical to the petitioner's attorney's duties. But here's where the respondent's attorney has a little bit of a different role. And this is why we call it the one with the principle of the matter. When an attorney is representing a respondent, they don't always have the best actor in the bunch. They may not have the best client. Sometimes their client's a jerk. Sometimes they're just a flat out bad person. But it's about protecting their constitutional rights. It's the principle of the matter. And so that respondent's attorney still has a duty to take those bad facts and do everything they can to protect their client's constitutional rights. A lot of times they know that they're fighting a losing fight. They know their client's not going to get it together, but they have to make that fight anyway. And sometimes when you are in the situation and you're seeing that come through, it's really hard not to get frustrated. Seems like those lawyers are stalling the process, or, why are they working so hard when their client's not making any real effort? But you just simply have to remind yourself they have a job to do. They have to protect the constitutional rights, and it's about the principle of the matter. Just like petitioner's attorney, they have an obligation to explain the proceedings to their clients in a way that their client can understand. Like petitioner's attorneys, they are officers of the court. They have to be respectful. They also owe a duty of candor to the court, and this really can create a dilemma for respondents' attorneys. They don't usually have the best folks in these situations, and I'll give you a real life example. One time I was representing someone who spent an hour on the witness stand telling the court, and I thought convincingly, I mean, I believed him. He told the court for an hour about how he wasn't using drugs anymore and it had been ages and ages since he'd done any drugs. And after an hour, the judge calls me up to the bench and he says, I think your client's currently under the influence. So you might want to go have a really frank conversation with him about this because I'm about to send him for a drug screen right now. So I take my client out in the hall. I said, hey, the judge thinks you're under the influence right now. Well, guess what I find out? Lo and behold, he was a little nervous about court last night, so he used some meth to calm himself down, and he was still coming down from his high as we spoke. So, now look, I've got a pretty good sense after 8 years of when I'm talking to somebody who's under the influence, but I had literally no idea that he was coming down off of a meth high. I wasn't really done with him testifying. I still had more information I needed to get him to get into the record, but you know what? I had to be done with him because I could not put him back on the witness stand after he had just spent an hour lying to the court. It was a mess. Needless to say, that was not a good day for me. It was not a good day for my client. So that duty of candor to the court can really create a tricky situation for the respondent's attorney. Respondents' attorneys also are bound by the rules of professional conduct, so we have to behave in the exact same manner. Now, we're switching gears to the guardian ad litem, or they're sometimes referred to as the GAL. This episode is called The One with the Guardian of Light, and I always have to laugh. This was an actual term that we heard to refer to a GAL one time in a case. And people, you know, that Latin term is confusing and it gets twisted around in your head and on your tongue sometimes, and you just kind of call it the closest thing you can. So it just kind of gave me something to chuckle over. Now, there is not a GAL in every single child custody case, but the statute requires a guardian ad litem if there are allegations of abuse or neglect. If there aren't allegations of abuse or neglect, the court can still appoint a guardian ad litem, and that can sometimes still be helpful. So for example, let's say we have two pretty good parents who mostly do a good job taking care of their kids, but they're so mad at each other that they can't focus on what's best for their kid because they're so busy focusing on what they want instead. And so appointing a guardian ad litem can help those parents or those parties get their eyes off of themselves and get their eyes back onto the kids and about what's best for them. Guardian ad litems are always attorneys. Missouri law requires that a guardian ad litem be a licensed practicing attorney. And in addition to that, they're also required to have special legal training over and above what's necessary to practice in other child custody areas. And so in order to be eligible for court appointments as a guardian ad litem, we have to have 8 extra hours that are specific to figuring out what is in a child's best interest. And so in addition to that, even, there are ongoing requirements each and every year for that continuing education. So each year they're getting extra education specific to, hey, how do we really figure out what's best for a kiddo? This is one of the most important things that you need to know about a GAL. A GAL gathers information, and they take that information and they formulate their own independent opinion about what's in a child's best interest. So in other words, they should never go in front of a judge and simply parrot back to the court what somebody's told them, even if the person who told them was the child. Instead, they have to form their own opinion about what is best for that child based upon their information gathering process. And so one of the things that really bothers me, I hear this a lot, I understand semantically it's easier to explain the GAL like this, but they are not the child's lawyer. That's not accurate. A child's lawyer would have the duty to advocate for what their client or the child wants, but a GAL has to advocate for what they believe to be in the child's best interest. So those are two very different things. Guardian ad litems participate in the case fully. So they are treated just like any other party. They can issue discovery, they can call witnesses, they can subpoena records, they can do anything else that any other party in a case can do. They have a duty of confidentiality. They must maintain a file. That file doesn't belong to the child. It doesn't even belong to me as the guardian ad litem. That file belongs to the court. And so before I can do anything with my file, I have to get an order from the court getting permission to do X, Y, or Z with that file. Can't turn it over to anyone unless the court orders me to. We also can't redisclose information except for some very limited circumstances. So if a child tells me something, there are only limited circumstances that I can redisclose that to others. If I get records that pertain to this family, I can't redisclose those things to other parties. Now, they might be able to get them another way. Maybe they subpoena them directly from the provider. Great, that's on them. But I can't redisclose that without some very limited circumstances being in play. There are some things, though, that a GAL can't or won't do. And one of those things is that we don't have a duty to prove allegations in a case. Remember that as the petitioner, you have the burden of proof. And so I think sometimes petitioners' attorneys might get a little bit lazy or busy. But whatever the case may be, I'd frequently get calls from parents who say, hey, my attorney told me to call you and tell you this so that you could get those records. Well, guess what? That's not my job. I don't have an obligation to do anybody's legwork for them. It's especially relevant because guardian ad litems are often the least compensated attorneys in a case. They are usually getting half the billable rate that any other lawyer in the case is getting. Courts usually are really good about getting cost deposits so that we know we have some money to pay for the work that we're doing, but those deposits are depleted really quickly in these cases. Everybody wants to meet with you all the time. You have a lot of people that you have to talk to and interview. Every time that you're meeting with folks, it's really depleting those costs. And so, guardian ad litems have to be very, very careful that they are managing their caseload very well so that they're not doing legwork that really should be someone else's responsibility. Guardian ad litems are just lawyers, okay? We don't get special privileges to go in and remove children from a person or a situation. Remember, we talked in our last session about who has the authority to do that, right? Juvenile officers, law enforcement, the courts. That's it. And so I took a pretty hard line during cases where I was a GAL. I didn't accept those quote unquote emergency phone calls outside of business hours, not even from other attorneys. When I would meet with parties, I would tell them, look, I am not law enforcement. I can't investigate emergency situations. So if those things arise, you need to contact law enforcement or Children's Division hotline if you think it's necessary. And then you can update me during regular business hours because there's not one blessed thing that I can do in the middle of the night. And that seems maybe a little bit insensitive, but again, the reality is that I'm just a lawyer. I don't have the power to go in and yank a kid up out of a situation. You need to get in touch with the people who do have that authority if you're concerned. I also never can authorize someone to disobey an existing court order. We just simply can't do it. Now, there have been a handful of times in my career where I really did feel like it's not in the child's best interest to keep doing this court-ordered schedule. And so if Children's Division's already looked at this or law enforcement's already looked at it and they didn't feel like they could stop it for some reason, the only option that I had was to file a motion with the court. And that's just not a quick process sometimes. And so there were some times where, as much as it stinks, we just had to wait it out and the kiddo had to keep doing the schedule they were doing until the court could hear it and determine otherwise. Guardian ad litems are not mandated reporters. The statute is listed for you there and it sets out who is a mandated reporter for the purposes of reporting suspected child abuse and neglect. There's been a lot of debate about whether or not GALs should be considered in that statute, but the general consensus is that we're not right now. Now, that doesn't mean that we can't make hotlines if we believe they're necessary. It didn't happen often, but there were a few times in my career where a kiddo came in and disclosed something during an interview, and I think, hey, that needs investigated. And so I did make a few hotline calls, but I'm not mandated to as a guardian ad litem. GALs are not the decision makers. Sometimes I think well-meaning attorneys say, hey, you know, the GAL is going to recommend blah, blah, blah. So that's just what you're going to have to do because the judge is going to do whatever the GAL suggests. The truth is GALs make recommendations. And it is true that courts sometimes give a lot of weight to those recommendations. And I think that's because they know where the boot's on the ground. They know that we get access to information that even they may not ever see. But they are not bound by our recommendations. I've been in cases where I made a recommendation and the judge said, thanks for that recommendation. I'm going to go do this instead. Or they've taken parts of my recommendation but not others. Sometimes they do adopt it word for word. But don't let anybody mislead you into thinking that the court is bound somehow by a GAL's recommendation, because that's simply not correct. Now we're going to talk about, really quickly, social workers and CASA workers. And I noticed one of our participants has an interest in serving as a CASA worker, so hopefully this will be good information for you. Social workers is actually a really broad category, and they can exist in a variety of forms, and they can be from different agencies, but they're not involved in every single case. A lot of times, social workers become involved with families because of children's division hotlines. So maybe a hotline comes in and a social worker comes out to investigate, and they say, look, we don't want to remove this child, but you need some services. So let's put those services in place and try to keep everybody in the home. Sometimes removal can't be avoided. And so in that case, social workers from Children's Division work with that family to try to provide the services that are necessary to try to fix the problem. What do we need to do to fix the problem so that this family can be reunified as quickly as possible? Sometimes social workers are not affiliated with Children's Division at all. Sometimes they are just providing services to a family as a result of another type of situation. Maybe they work with programs like First Steps or Parents as Teachers. Maybe they're just regular run-of-the-mill mental health professionals who are providing therapeutic services to a family. They may also be involved as a result of school. A lot of times families have social worker involvement because there are learning issues with a child at school or behavior issues, and that school social worker then can try to work with that family and provide the assistance that they need. Social workers can be called to testify in court cases. Most of the time, they also have a duty of confidentiality. So very often, they have to be subpoenaed. In other words, they can't just voluntarily agree to come and testify. They have to receive a subpoena. And even once they are subpoenaed and appear for court, they have to be ordered by the court to provide the testimony about the work that they've done with the family or with a child. Now, CASA workers are similar to the other types of social workers we've looked at, except that they may not have formal education in social work. They're simply volunteers that are working with these families. And CASA stands for Court Appointed Special Advocates, and we find them in cases that are heard in juvenile court and cases where there are abuse and neglect. Other social workers often have really heavy caseloads, but CASA workers tend to work with really small groups. They might only have 1 or 2 children or sibling groups at a time. And because of that, they can meet with these kids a lot more frequently. And then kids hopefully have the opportunity to really bond with that CASA worker, and they will feel freer to open up and express their thoughts and feelings. It really helps them to be able to formulate that bond. In turn, then, CASA workers make periodic reports to the court about what that worker believes to be in the children's best interest. And like other social workers, CASA advocates can be called to testify in court cases. All right, so now we're coming back to the judge, the person initially that we thought might be the most important. We're going to kind of sum up with what their role is in all of this. They are the one who decides it all. So when the parties can't agree on what custody arrangement is best, a judge decides that. They can't have preconceived notions about a case, though. In other words, they can't say, hey, custody is going to go to mom because, she's the mom. We used to hear that one quite a bit. Another one that I've heard, well, grandpa's trying to get guardianship, but, he clearly didn't do such a great job with his own kids, so why should we give him this one to raise? That can't be a consideration for courts when they're deciding this. Judges cannot use those preconceived notions to decide cases in a certain manner. They have to treat parties with respect and allow them a reasonable opportunity to present their cases, even if they're not represented by an attorney. And ultimately, judges are the ones who make the decisions about what evidence is presented or admitted to the court. So an attorney offers a piece of evidence, the judge has to decide if that's appropriate to be considered by the court. They also decide how much weight that evidence should carry. We talked about evidence and how not all of it is created equally. They have to evaluate the credibility of the witness, they have to evaluate the credibility of the evidence itself, and then make their decisions based on that. Judges have to follow the law. They swear an oath to uphold the law, and that's true even if they disagree with the status of the law. One of the general principles is that frequent, continuing, and meaningful contact with both parents is in a child's best interest. And that is true whether it's a case involving a parent versus a parent, or whether it's a third party or a relative versus a parent. The general principle is that children need frequent, continuing, and meaningful contact with both parents. However, facts matter. And so when our primary concern is still the best interest of the child, if a court finds that abuse and neglect has happened at the fault of a parent, that parent's contact can be limited. Now, as the judge, it's really sometimes difficult to reconcile what the law says versus what may be in a child's best interest. These are rarely easy judgment calls for them to make. A lot of times judges have their guts screaming at them, something's really wrong here, I don't like this situation. But in the absence of having properly admitted evidence that would justify some sort of different outcome, they may have to make a decision that they really wouldn't want to make. They can't just ignore the law because their gut tells them that something's wrong. It's really tough to balance, what the law requires versus what's in a child's best interest sometimes. Ultimately, everything rises and falls with the judge. They are the decision maker, the arbiter of what that custodial arrangement needs to be. And the reality is I wouldn't want their job for love nor money. I wouldn't want to sit in their robe for even a minute. It's a very difficult job. Now, occasionally, you find that there are a bunch of other people. We might also see an episode called The One with All the Extras, because there may be faces in a courtroom from time to time that you might not expect to see. Things like additional witnesses. Maybe you need people who can come in and help establish your good character as the petitioner, or people who can establish another party's poor character. If law enforcement's been involved, they may be there to testify. Forensic interviewers. All of those folks may be part of that process. It's always a concern when there are a lot of witnesses that as they sit in the courtroom and see and hear the things that are going on, their story may change. And so any party has the right to do what they call invoking the rule. And that simply means if you're not the petitioner, a respondent, a minor child, or an attorney representing one of those people, you're going to be made to leave the courtroom until it's your turn to testify. And then after you testify, you can stay in the courtroom if you just want to be nosy, but you don't get to sit and listen to everybody's testimony and then change your testimony accordingly. There may also be complete strangers in the courtroom. Not all cases are closed to the public. In fact, generally speaking, most are not. Exceptions to that, juvenile cases are confidential. That would include delinquency and abuse or neglect. It includes adoptions. And then the judge can always have the discretion to close a courtroom if he or she feels it's appropriate. But most of the time, you may find some other faces in there that they're people who are waiting for their own cases to start, or maybe they're just nosy. They just want to be in the know. So it's not surprising to see those folks from time to time. So, okay, that's it. Those are all of our players. Those are all of their roles. And we're going to do one quick test your knowledge question. And so be ready to throw an answer up in the chat box. Just type the letter in of your choice. Which of the following individuals are always required to participate in child custody cases? Option A, the judge, the GAL, the petitioner, the respondent, and the minor child. Option B, the judge, the GAL, the petitioner, the petitioner's attorney, and the minor child. Option C, the judge, petitioner, and the minor child. Or option D, the judge, the petitioner, the petitioner's attorney, and the minor child. We'll give you just a few seconds to make a selection in the chat. Okay, and it looks like we have several that are coming in. And the correct answer is, in fact, C. The judge, the petitioner, and the minor child. Those are the ones who are always required to participate in child custody cases. Keep in mind, not every case has a guardian ad litem. Not every case has a respondent who participates. Not every case has an attorney that represents a petitioner or a respondent. But there's always going to be a judge. There's always going to be a petitioner or someone who brings an action, and every minor child custody case has to have a minor child. So that is correct.